I want to at least start by acknowledging country. So where
Sure.
I work, where I'm working and living on the Gadigal in the Eora Nation, part of the Gadigal people of the Eora Nation, and I want to acknowledge elders past, present and emerging. I'm not sure, Kumar, if you want to do any formal kind of introduction or you just want us to introduce ourselves.
Please introduce yourself because I can't. I've lost my voice.
Yeah.
Thank you.
So my name is Sarah Ibrahim and I am a commercial solicitor. So I've been working in the commercial space for the last about 3 years, but prior to that I was a human rights lawyer. What I thought I'd do is get started by sharing with you some basics around business structures. I don't know yet whether you've already picked what structure you're going to operate in, but I thought I would give you kind of the advantages and disadvantages of the basic business structures. And then I thought what we would do is kind of briefly touch on some business legals. So we're going to briefly touch on things like terms and conditions, employment law, privacy insurance and leases, just briefly. So I'm going to share a screen with you now, and it's a little bit one of those situations where I won't be able to kind of see your facial reaction, but maybe if you put some messages if you need to ask a question so I can see you, or I'll try to stop in between. So I won't be talking for that long, and then I'll pass over to Shari, and she'll be able to talk in a little bit more detail about companies and director duties. And then George will take over from me, and he'll be talking. He's the expert in IP, which means he'll be talking to you about commercializing a lot of your ideas and concepts, and he'll go from there. So let me get started by sharing this screen. Okay, so just getting started on the first one, which is sole traders. And a lot of you might start there because it's basically the cheapest and easiest structure to form and dissolve. Some of the other advantages are that you'll have full control, and therefore you'll be able to make, you'll have freedom to make decisions about the business. You can take all the profits and access to all of the taxable losses directly, and it's easy to run and keep records with fewer government regulations. The other thing about running as a sole trader, basically you register your ABN and you'll be on ABN lookup with your name. So you trade as your name, but you can trade with a business name if you register it. But things like your address, your date of birth, your country of birth, shareholders, they're not recorded on a public register with ASIC like a company. And you basically pay income tax rather than corporate business taxes. And you'll have a direct relationship with your clients. So some of the disadvantages, and one of the main ones, is really the liability issue. So what it means is there's unlimited personal liability to your personal assets and business assets. But what that really means is that if you acquire debts through the business and the business is not able to pay for those debts, that means creditors can come after your personal belongings, assets, and that's why there is that other element of liability and risk there. It's also not a separate legal entity, and basically once your business starts to grow and you have a lot more profits, it means that you end up with a higher marginal tax rate because you're paying through pay as you go, as opposed to using company tax option, and because you're unable to split your income. So as you're growing in that type of business, usually people start off as a sole trader if they're starting small, but then over time as you grow, you consider restructuring. It's difficult also to raise money as a sole trader, and you can appear as small, but depending on what you venture into, sometimes that is the best structure to start off with. And the other one is partnership. So I don't know if any of you are starting a business with a business partner. There are some advantages, which is sharing responsibility and obligations. The other advantages are that there's a written partnership agreement, and that can clarify basically how your partnership agreement, what the obligations are in relation to its operation and its dissolution. There are tax losses that any tax losses that you basically incur will be accessible to both you and your partner, and they can be used to offset your tax liabilities. And it's easy to run and record in the same way that being a sole trader is, with fewer government regulations. And the same thing where you don't have the requirement to file the business activity statements, the BAS. And I mean, you do if you're registered for GST, but generally your income tax is only paid yearly. And then looking at the disadvantages is that basically the liability is, you can be basically what we call collectively or separately liable for the debt, or jointly and severally. That's another term used by lawyers. But what it means is that your partner could incur debt for the business and you're still responsible for that personally. And you also have to think about actually drafting a partnership agreement. So that's where you kind of bring lawyers in. Generally, when you're starting a business, it's good to speak to lawyers. And the other thing is that it's not a legal entity, a separate legal entity. And basically, again, the same thing with the taxes. If you're basically, once you start earning a lot of money as a structure, it doesn't allow for splitting, other than splitting it with you and your partner, but there's other higher tax liabilities because you're personally paying through pay as you go. And it's hard to raise capital sometimes, and you can be responsible for the shortfall of your partner. And it can be difficult also to change your business partner. Now, looking at the company, I won't talk too much about that because I know that we're going to cover that somewhere else. But basically, the main advantage is the limited liability, your personal liability, which is limited to the shareholders' amount unpaid shares that are held by the shareholders. So it is the advantages are that it's a separate legal entity, and it's easier to raise money, and there is the succession with the business that can basically endure passing it on, or should you pass away. And also there's a lot more structuring benefits, and it's suitable to the expansion. But the disadvantages is that it is expensive to basically get started. I think the fee is about $512 to register your company with ASIC to get started. And as I was saying, that a lot of your personal details are on a public register and are recorded for people to look up. And I think that the other thing is that either way, when you have a turnover over 75,000, you start to think about registering for goods and services tax, GST. You basically have to comply with the Corporations Act. And like I said, those details will be the Corporations Act and there's a lot more regulation, but I won't go into any of that. I'll leave that all that. Let's go to trusts. Now, trusts are a little bit more complicated. I won't spend too much time on it, but there are basically the advantages are that the beneficiaries of a trust are generally not liable for the trust debts. Usually there is a company that's created as well, and that can again give you the benefits, as we're talking about with the company, of limited liability in some way for the and it is easier to raise money, and there are obviously, like I said, these financial tax benefits. It's basically also used a lot for asset protection. It's as a structure, as well as thinking about the disadvantages. Like you wouldn't be in a rush to get into this structure because it's very expensive and complex with a lot more regulation. So let's go to the next topic, really, just going over some business legals. So there's terms and conditions, employment law, privacy insurance, and leases that I'd mentioned.
Sarah, sorry, could I just ask a question there before you go into the next slide?
Yeah, sure.
I've asked this before, but I am looking for clarity for social enterprises. There's more and more businesses now that are purpose and profit. And what that means is that's what I've started, and the profits go back directly back into the business to sustain the purpose. So I'm looking for the best legal model that enables me to minimize tax, because I don't want to be paying tax on money that is actually, it's not income. It's just going back into the business to sustain it and to scale and build it because it's got a for purpose agenda, I suppose. So do you have any experience with social enterprises, and what would be a better structure?
Basically, there's either incorporated or unincorporated. And so incorporated means some of the stuff I'm talking about in relation to companies, you get the benefit of, whereas unincorporated is a little bit, not like it's not exactly equivalent, but it's a little bit like talking about the sole trader, where it's individuals that group together with a common interest. And but that again means that the individual is then liable, or the collective of individuals that are grouped together. So I don't know who you're doing this with, but there are minimum requirements to start these organisations. So there is benefits to incorporating these types of social ventures and ones that are charity run. There is benefits. But it is something you individually kind of have to sit with a lawyer, and they have to go through a lot more detail rather than, but just broadly speaking, I think when I'm talking about those things, what I think you should think about is where I've compared the corporation, that means in your instance, it would be an incorporated association. And where I'm comparing sole trader, you think about it as unincorporated associations when you're thinking about the pros and cons, just broadly. But in terms of really getting into the nitty-gritty, you know, we can talk about that in more detail. But does that give you any more clarity about it?
Yeah, I think I do need to sit with someone one-on-one and just go through the details to see what's the best option, because I've been exploring this for a while and I'm just don't seem to be getting very far.
Yeah. Well, yeah.
Thank you.
I mean, there is. We can talk about it basically offline. But let me keep going.
Sure.
Great. All right. So terms and conditions. Basically, some people use generic ones that they find, but lawyers also draft these types of terms and conditions for people that are running businesses. A lot of people run businesses where they're doing a lot of things online, websites, e-commerce. But basically, your terms and conditions are where... Sorry, that's my little one screaming. So it's where basically you set out what the expectations are for your customers or your clients, and your expectations, what your fees and charges are, the payment terms, whether you require any credit checks, depending on, you know, what it is that you're each doing, what the cancellation and refund policy is, which is an important one, any dispute resolution processes, and any way to terminate sort of contracts, essentially. So things to think about in your checklist is if you're operating a website and you're sharing information written or visual, then you should think about terms and conditions. Or if you're selling products or promoting services, that's another time to think about terms and conditions. You should also be thinking about the Australian consumer law, basically, that's regulating traders. So all traders are regulated by the ACL. That's what it's referred to, ACL. Where there's a lot of minimum requirements that you should be thinking about when you're selling goods and services. The basic entry level is, you know, there can be no misleading and deceptive conduct, and that's really important for you to think about. Just the way you basically kind of advertise or present or make representations about something, you have to think about making sure that there is no misleading, deceptive conduct, as well as generally it's protecting, you know, minimum standards in relation to goods being fit for purpose, that they are of a particular quality and standard, and so there's a lot of basic things that are all encompassed in the ACL. It's a very big set of legislation. And warranties. The other thing to think about, I guess, is, do you have any, if you're selling goods and services, there's things to think about like refunds, replacements, other than what the ACL will say broadly about concepts of a warranty, but that's more about the quality and standards of goods. So you have to kind of make sure also that you outline and you're clear about your fees and charges. And you should think about in your documents ensuring that they're clear and enforceable. So it also depends on how you describe things. And so these things are thought about, like lawyers spend time thinking about all the words, basically, all the words that are being used to describe something to ensure that we're compliant with the ACL. So it's something for you to at least turn your mind to, that depending, because I know that there's such a variance of what everyone would want to do or be starting. But let's go to the next slide. Now, employment law. I like doing employment law. The way I've broken it up is, if you are thinking about bringing on people, then you should be thinking about, are they going to be employees or are they going to be independent contractors? That's generally the question that you would ask yourself. So just broadly speaking, what I'll do is it's really there, but it's outlining the difference between them both. So independent contractors are basically where, somebody has their own ABN, and you don't really have control of when exactly they do the work. Generally speaking, they're meant to be independent, and they basically invoice you, and you think of things like either specific tasks, but they bear their own risks, and they also bear their own responsibilities and liabilities in relation to, generally speaking, in relation to insurances, and they usually have to pay their own super, and they have to pay their own taxes. So they would invoice you generally and probably include, some of them might be registered for GST, so they could include GST when they bill you for their time, and they don't receive paid leave. So whereas employees, basically, they work within a structure that's regulated under the Fair Work Act generally, unless they're state employees, but not in this instance. So all employees would be under the Fair Work Act, it's federal legislation, and it sets out that there is minimum employment standards. So you've also got to think about, when you're employing people, is there a particular award that they have to work under? And then when you're employing them, you have to think, is if you've thought about the award, which is sometimes why you need a lawyer, because then you need to go, what are the relevant conditions and pay for the award? And every different industry actually has its own award, which is a bit of a minefield, actually, employment law, which is why so many employers get it wrong. You see them on the news, you hear about them, because it's actually quite complex. So sometimes it's not necessarily that, there's a lot of conversations around wage theft as a concept, but a lot of it is because it's very complicated, basically. It's complex if you've looked at an award, and that's why people get employment lawyers involved. If you're paying someone over a gross amount of $450 every month, then you need to consider statutory requirement for superannuation, which is 10% at the moment. And the other real benefit of having employees is that they perform work for you under your direction and control, and it's usually on an ongoing basis. And it's usually with standard, they work standard set hours, generally speaking. I mean, you can have a casual that works all over the place. And they bear no financial risk, really. You bear their risks of taking them on and continuing their employment, and you usually supply them with their equipment and tools, and you usually withhold their tax, and you pay them regularly. So with a contractor, it might be that they get paid 6 weeks after they do the work, but with an employee, you're generally going to pay them within a week or two of doing their wage or their salary, and they're entitled to leave, and the leave is generally set out as the minimum standards, just broadly speaking. And I don't know if you're all going to, usually people don't necessarily start off and the first thing they do is employ someone, but it could be an industry where that's exactly what you need to do. So it's really important to think about the differences and how that might impact your business. And the other thing is if your business is collecting personal data, for example, on a contact us page or subscriber list, you should consider and disclose what your policy is regarding collecting the data, storing it, and how and when you might disclose it. So there's a lot more detail in the Privacy Act, but it's really not needed for this kind of conversation. But I just think, broadly speaking, you should think about that as a concept. In terms of insurance, I mean, this is really important, to be honest. You should be thinking about, where you're working. Do you have public liability insurance? Do you need any professional indemnity insurance, the business insurance, director insurances? There's so many different types of insurances. But the point is, do you have adequate insurance for your business? And do you know what the policy that you're insured under covers? And have you made sure that the insurance policy is checked against your lease requirements? So if you end up renting somewhere, commercial or retail, they'll usually tell you there's a minimum requirement for insurance. So that's something for you to think about. And finally, the last slide was leases. So another thing that I do is a review commercial and retail leases, and it's really, it's not the same as your residential tenancy lease. So it is actually more technical and important to have it reviewed by a lawyer, because what you'll see in the terms and conditions of these leases is they'll talk about things like outgoings, and sometimes they'll define that, and sometimes that can be up for negotiation. And there's certain things that are written and the way they're written that could increase your liability or reduce it, depending on having a lawyer advocating for you. Obviously, the rent amount is an obvious one. Everyone knows that to start with in terms of what is the rent and how can I negotiate it. But there's also things like make good provisions. And this is the stuff that I know dealing with commercial litigation at the other end when things go wrong. So the things that have occupied a lot of court in relation to contract law, there's two things that a lot of Australian contract law was formed, and a lot of it was commercial retail leases and contracts of sale for the sale of property of land in Australia. So these are spaces where things can go wrong. You have to think about what the options are for renewal. When does it expire? How does the rent increase? Is it indexed against CPI? And the most other important one that impacts you individually is if you've decided, for example, to incorporate a company, but then they've said to you when you go to sign a lease, you have to provide a personal guarantee. What that does is make you basically personally liable for this lease, should there be any default. So it's a little bit like that whole sole trader thing again, where once you're personally liable, that means your personal assets. So it's becoming more and more common with commercial and retail leases anyway. And I guess that basically wraps up the final kind of slide in relation to leases. I know that the three of us have been speaking, the presenters for today, and that we will be taking questions at the end. So I don't want to be rude, but if you do have a question, there will be opportunity at the end. I want to hand over to my colleague, Shari. Thank you for patiently listening to me.
Hi, everyone. Good afternoon. Thank you, Sarah. This obviously very related to what I'm covering. So thank you so much for those insights and broad information about the types of businesses and from commercial point of view. I'll just have to share screen. Just one. All right, everyone. So in the context of the conversations, so my name is Shari Rafi, and I'm a managing partner of a small law firm. I have set up the firm since 2 years now. I'm a corporate commercial lawyer as well. I've worked since 2013 in different organizations. I started with a private firm. Then I worked for all the Australian big banks like Commonwealth, CBA, PayPal, and I worked with federal government and the state government before going private and establishing my own law practice. So at Lex Global, Our main practice area is corporate commercial conveyancing and property law. We do bits of immigration and family law as well. And our preferred model is to act as outsourced lawyers for small firms, just like Sarah's, I'm assuming. So I can't see you all, and I'll just be looking at my screen. We do have question and answer session, so you can record your questions. If I can answer at the end of the question and answer session, that's fine. Otherwise, I'll definitely get back to you through Kumar or the email that we have. My topic today is on directors' duties. You all are basically embarking into a new venture, and you're establishing businesses with a sole trader, or you're establishing or registering a company. Regardless of the nature or model of your business, as directors, you will have responsibilities and duties under the law towards your company, and those duties are highly regulated, and they're very, very serious. And in the Corporations Act, and if you have registered a company, then you are obviously captured by all those duties under the Corps Act. I will take you guys broadly. I will literally introduce some of or most of those duties for you to have a broad understanding, just to avoid any headaches or potential breaches when you're dealing with your day-to-day business activities. I will hope that you will understand at the end of the slides that who are considered to be directors and what are the core director duties. Do directors have obligations under other laws except the Corps Act? And what are the consequences of breaching those duties, and what duties exist in organizations not governed by the Corps Act? Every company, or most of the companies, they have board of directors, and board of directors are responsible for overall supervision of what happens in an organization. The relationship between one of the main duties that a director has towards a company is a fiduciary duty. Fiduciary duty, I will explain to you guys what it entails more in details, but mostly what fiduciary duty is. I'm just having this. This screen is just covering my. So general duties of directors, as I mentioned, when you establish a company, then you're protected by Corps Act as individuals, obviously, because when you establish a company, as Sarah was mentioning, a corporation is a legal entity separately from its directors. So a corporation can act separately. They can enter into transactions, enter into contracts. They can take loans. They can deal with different types of stakeholders as separate legal entity to its directors. So directors are to an extent protected, subject to compliance with their duties. So if they are at times that if their directors are found to be in breach of their duties, then that's the time that perhaps then there will be consequences for those directors on a personal level. And at times, those if they are found in breach of their duties, for instance, if it's insolvent trading, then the creditors can come and they can go after a director's personal accounts and personal assets. So that's the reason that complying by Corps Act and complying by your duties is really essential on running your businesses as company directors. So one of the main one of the duties is a fiduciary duty, or a fiduciary relationship between a director and the company. It's a relationship of trust and confidence. Fiduciary represents and exercises power or discretion affecting the interest of the principal or beneficiary. So the fiduciary duty also requires the directors to avoid conflict of interest. So I will go more in details to explain what conflict of interest means. It's basically when a director finds the personal interest in conflict to the interest of the company or the organization, that's where then they have to avoid those scenarios and they have to minimize it. Otherwise, that's an instance that they can breach their fiduciary duty, or avoid their conflict between the interest of two beneficiaries, or not profit from their position. So not profit, it doesn't mean reasonable profit, or a profit profit that's like perhaps a salary or a share or dividends, whatever they're getting, which is within the realm of their duties or responsibilities or the incentives that they receive as director. But that's just, we're referring to unnecessary or illegal benefiting or profiting from the position as a director of the company. Who are considered to be directors? Directors can be legally, validly, and formally appointed, but there are scenarios where directors can be a de facto director as well, or a shadow director. So it doesn't require formal procedure to appoint that director. So we can't imply that there are scenarios where people are operating and they are performing all the duties and responsibilities of someone that can be deemed as a director, but they have not followed through the formal procedures to be appointed as director, and they are not included or their names are not mentioned in the company records as a director, but they're actually exercising those powers and duties and responsibilities. So that's when they cannot still get away with the fact that I'm not on paper a director, but I have been acting as a director. So that means you can still be held accountable if you are in breach of your director's duty, or you have responsibility to comply with your duties as a de facto director or a shadow director. So some of the main duties of directors have been listed here. So directors' duties, you have to, as a director, you have to manage conflict of interest. Obviously, you have to prevent insolvent trading. Insolvent trading is those instances where a director can understand that the company cannot meet its dues when its obligations towards the creditors. So, for instance, a simple example will be a company has taken a loan and they have been struggling and they have been continuous default on the company's ability to pay those loans when they are due, but the directors continue and they take risk to continue the business and they operate as usual. In this instance, the directors have a duty to put a pause on the business and to discuss with administrators or with professionals or in this area to determine the solvency of the business, rather than risk the business becoming insolvent, because the business clearly is not meeting its obligations towards the creditors. It's finding it hard to pay its dues or its loan, basically, simply saying. So those are the instances that directors can be found in breach of directors' duties, and the creditors can come after their personal assets. Provision of the director information is another duty, which I will explain. Conflict of interest as well. Not improperly using information or position as a director information. It means that directors have unlimited access to companies' data, information, and they should not use that improperly. Directors are required to act in good faith in the best interest of a company and for proper purpose. Act with reasonable care and diligence, and their statutory duties of financial services, apart from Corps Act, your financial services, consumer law, environmental law, work health and safety laws that also hold directors accountable. It's just not the Corps Act that directors have to comply with. So as you understand, in Australia, we have both common law and we have the legislation, the statute. And directors' duties are pretty similar, both in common law and in the legislation, which is Corps Act. And in general law, so you can see that we have loyalty and good faith, fiduciary duty, and then we have the duty of care, skill, and diligence. So under general law, common law, we have act in good faith in the best interest of the company, exercise power for proper purposes, avoid conflict of interest, duty to retain discretion or keep discretion unfettered. Corporations Act is pretty similar, section 181, subsection 1A, good faith, best interest of company, then for proper purposes, not misuse position or information, related party transactions, that's kind of similar to conflict of interest, disclosure obligations, that's for in case if a director's information is required, they have to disclose it, or they have to disclose if they're conflicted, if they have conflicting interest. Then again, we have under general law, under the duty of care, skill, and diligence, we do have equitable duty of care, the directors can be found negligent under the tort of negligence. This is under common law, and under contracts, executive directors' term of employment contract to exercise care. So that's under contract law as well. They can be found or held accountable, and duty to avoid insolvent trading is covered under Section 688G of Corps Act. The duty of loyalty and good faith under general law and statute, they have been, they're pretty similar. The duty of loyalty and good faith is to retain discretion, avoid conflict of interest, act in good faith and in best interest of the company, use powers for proper purpose, and in the law, legislation, or Corps Act is the same. Disclose certain information that is that relates to the director itself if it's important and it's necessary for the best interest of the company. They have to disclose. This is more relevant in the context of for instance, if a director holds a share in a certain company and then the company is going to accept, for instance, proposals from that company, and this director is conflicted in this scenario, so they have to disclose those information in advance, or if their family members are conflicted. So those are information that they have to disclose. Related party transactions is also in the context of conflict of interest, duty not to misuse information or position or act in good faith and for best interest of the company. I'll just go more in details as to what it means to act with care and diligence. That requires a director to become familiar and maintain familiarity with the fundamentals of the business or businesses of the organization. So a director cannot just sit back and like, it depends on how big the company is, obviously, but a director has a duty to always understand what the actually what business the company is doing, and it has to research and understand the company activities and not just rely on different branches or different sections that are responsible for different aspects of the business in the company. So directors have a duty to be aware. Directors have to monitor generally the organization's affairs and policies, maintain familiarity with the organization's financial status by appropriate means, including reviews of its financial statements and board papers, and make sure further inquiries into matters revealed by those documents where appropriate. So that it means that directors cannot just rely upon the fact that they have outsourced their responsibilities to a lawyer or to accountant or to a tax team. They have to be aware and they have to understand those financial documents and the operations of the business overall. And they need to have those professional knowledge as well. That is when they will meet the duty of care and diligence. But then again, law is very fair. Law doesn't want the directors to be scared of breaching their duties and not make any business decisions. So then the business judgment rule comes into play. So this rule seeks to avoid unnecessary restrictions on proper business activities. Section 180 of 2 of the Corps Act provides that the director who makes a business judgment, that is, any decision to take or not take action in respect of matters relevant to the business operations of the company, is taken to meet care and due diligence requirements in respect of the judgment if they comply with the following requirements. So this business judgment rule is only relevant to the duty of care and diligence. This basically means, put it in simple terms, it means that if directors are complying with these four or five elements, then they can make any business decision for the interest of the company. So they shouldn't be hesitant, or they shouldn't act prudent that, I may do this and I make this business decision, and I may breach my duties as a director. But if you make the judgment in good faith and for proper purpose, and you do not have any material personal interest in the subject matter of the judgment, and you can balance your conflict if you're conflicted, inform yourself, if the director informs itself about the subject matter of the judgment to the extent that they reasonably believe to be appropriate, and rationally believe that the judgment is in the best interest of the corporation or the business, then then they can make any business decision within the realm of those requirements. So other duty of a director is act in good faith in the best interest of the company and for proper purpose. So directors must exercise their powers and discharge their duties in good faith and the best interest of the corporation and for proper purpose. It's clear that the corporation has a distinct legal entity, just as we explained. It's a completely different legal entity to the directors itself, is the focus of this duty, and that it requires consideration of more than financial returns of profitability over a particular period. In particular terms, acting in a reasonable and ethical manner towards stakeholders such as customers, employees, community, and the environment is a necessity for the promotion of the interests of the company and its sustainability and best long-term value for shareholders. The duty to act in the best interest of the corporation came under scrutiny in the context of Banking Royal Commission. I'm not sure if you all have heard about the Banking Royal Commission inquiry. It was very, very lengthy inquiry, mainly into the banking sector and how banks were mainly the commission-based policies, and there were a lot of issues within the financial services industry that they were in breach of, they found to be in breach of their directors' duties, and there were a lot of company directors that they were literally under scrutiny. The big banks were under scrutiny. The policies were, and then based on after the findings of Banking Royal Commission, the directors' duties and the compliance in each financial services industry has been taken very seriously to make sure that directors are not perceived to be off the hook whenever they run a major corporation and they think that they have all these thousands of sections to oversee, so they're off the hook because they are like a big guy sitting there on the top. No, it doesn't happen like that. So you have to be aware of your day-to-day business and the financials of the company, even if it's a massive corporation. So core duties of directors, and obviously the findings of banking, the commission on the Royal Commission on the banking sector is quite detailed. It's mostly focused on the banking sector, which is not relevant to our topic today, but it just emphasizes further how important directors' duties are, regardless of how big the organization or how small the organization is. So not improperly use information or position. So directors are in a position where they have discretion, they have authority, and they make any decision, but their decision cannot be improper, and their decision, or they have to use their position for the best interest of the company. And they have unlimited access to to information, confidential information, or to insider information within the company, and they cannot use that improperly. That can eventually damage the reputation of the company or the corporation or the business or its business and longevity. So directors will not improperly use their position or information they obtain because they are or have been a director to gain advantage for themselves or someone else, or cause detriment to the company. These prohibitions stem from a director's fiduciary duty to prevent conflict of interests and obligation to act only in the best interest of the company. So example is directors may improperly use position if they act without authority or take asset of the company or accept bribe, secret commission. That's when they are in breach of, they have misused their position. So managing conflict of interest. Conflict of interest is a very interesting topic, and no matter if you're working in an organization where you're simply a director or you're running your own business and you're an appointed director or the only director of your business or one of the directors of your business, it's inevitable that you'll find yourselves in a position where your personal interest might be in conflict with the interest of the company. And I can perhaps clarify that with a few examples. Conflict of interest is, for instance, nepotism, hiring your own children, spouses, relatives, while they're not qualified enough to do the job. So if they're not qualified enough, who suffers? The business suffers eventually. So this is where you are breaching your duty, because you're resorting into nepotism and you're bringing people who are not qualified because you're personally conflicted. Or for instance, you have a company and then you're going through this bidding process where you're accepting proposals, and you know that, for instance, your spouse or your cousin or your children, for instance, or your neighbor, someone that you know, or a company that you hold a share, is also submitting a proposal. And you have to be completely open about it. You have to avoid this scenario, and how you can do it is by disclosure. It doesn't mean that you should not hold shares in a company. It doesn't mean your family should not have another business, but you have to disclose this. And by this, it means you will avoid breaching your duty of conflict of interest. And then the other directors in the company or other shareholders will decide whether they want you to be part of the decision-making process, or whether they will allow you to vote or to make decision in that process. So that's basically, you can avoid being conflicted or breaching your conflict of interest duties. That's about it. Okay, so as examples, it may be required that the conflicted director refrain from, so the ways is that refrain from participating in any discussions about related matter that you're conflicted, or remove yourself from the room, completely leave the room. There are a lot of like board meetings where one of the directors is conflicted and they have already disclosed that conflict. They will just simply be ethical and just leave the room, because they will make a decision that's not for the interest of the company potentially, but for their own personal interest, or abstain from voting on the matter related. So conflict of interest, I just copied and pasted this one from Google, just as we were speaking earlier. It can be actual, potential, or perceived. So it doesn't mean that it's an existing interest. It can be an actual, which is an existing one. For instance, if you're in a close relationship with an employee of the organization that you're a director of, and you're promoting that employee, and without that employee being entitled to, or for instance, you're giving the employee gifts, or you're giving more salary than other employees because you simply either conflicted for whatever reason. They're related to you, or you're interested for whatever reason. So that is that's when you're putting yourself in a position of conflict. Or it can be potential. For example, you're a director of two charities that they both compete for the same grant in the future. So it doesn't have to be, or for instance, your wife is or husband is opening a company that potentially will provide a service that your company may offer bidding or go to the market for other companies to submit proposals. So that's potential conflict of interest. Or perceived is there may be appear to be conflict of interest. For example, when you're an investor in a company that you board but may be perceived to be able to influence. So it's a perceived conflict of interest that you have, that perhaps you have share in a company, and then there's a perception that perhaps you have more interest towards the benefit of that company that you hold shares, and then there's a perception that based on the perceived conflict of interest, you may you may not act on the interest of the company, but for the interest of the company, but yourself. So with companies, I think there are two types of companies that you might have heard. It's public company and then private companies or proprietary companies. Public companies, they meet certain criteria to be able to sell their shares in an open market. So any individual or corporation, they can go and buy their share and they become a shareholder. And the public companies have different obligations under the law than proprietary companies. And it doesn't depend on how big the company is to become public or private. There's many proprietary companies that are really big and they haven't become public. So it obviously it meets certain threshold and criteria, but it doesn't mean that it depends on how big the business is to be labeled as proprietary or public company. So public company directors are prohibited from participating and voting at board meetings that consider matters in which they have a material personal interest. There are some exceptions. Other directors vote to allow the director to be present, and the public company, they can be those exceptions. ASIC order allowing director to be present or interest does not need to be disclosed under Section 191 of the Corps Act. And under proprietary companies, obviously legally there are different obligations, different laws related to both types of companies. Corporations Act does not prohibit an interested director from voting. May be prohibited by constitution. Most of the companies, they have the constitution and they can do that. Section 194 replaceable rules. If a director make disclosure to board under Section 191, director can vote. So there are different rules for public or proprietary companies. Another core duties of a director, as we mentioned, is preventing insolvent trading. And solvent trading, as I mentioned earlier, to explain it in simple terms, is to avoid the company becoming insolvent. So we use the word bankrupt in Australian law for individuals. We use insolvent for companies. Is this different in US, or in terminologies in the US? You can hear that businesses are bankrupt, but in Australia you use insolvent for companies and bankrupt for individuals. So a director has a duty to prevent this, to prevent insolvent trading. Insolvent trading is when a company is still running as business as usual while it is struggling to pay its debt. So that is when a director has to put a pause and hold a meeting with shareholders or with other directors, with employees, whatever it takes, with all the stakeholders, to understand what can be done to save the company, enter into administration, or declare the company insolvent, because the company obviously is struggling to pay the debt, and there are one or two or multiple creditors waiting to, or shareholders to get their dividends, or creditors to get their debt back, or the company has to pay their liabilities. So if the director continues to do so and ignore the fact that the company has financial problems, that's where the directors will be found to be in breach of the duty of preventing solvent trading, and creditors will go after their personal assets. Directors have a duty to ensure that a company does not trade while it's insolvent or where they suspect it might be insolvent. The directors will be personally liable for certain debts which are incurred if they are a director at the time when the company incurs the debt. So obviously, if the director wasn't a director, but they're current director, but they were not a director when the company borrowed whatever they borrowed, or they incurred the debt, the company is insolvent at that time, or becomes insolvent by incurring the debt. So, I mean, obviously, when the director is an active director and the company starts insolvent trading, not a director that's hired when the company actually becomes insolvent, those directors are not held accountable. At that time, there are reasonable grounds for suspecting that the company is insolvent or would become insolvent. So in law, there's always objective tests, and the court will determine whether any reasonable director in the place of those directors would have suspected or would have understood that the company is insolvent. And there are obviously clear examples that the company is not able to pay their debt, and that's a clear example that the company should have been stopped to trade. And there are obviously defenses. One of the defenses is safe harbor protection. And insolvency safe harbor protection is available to directors. Directors can use this as a defense if at a particular time after a person starts to suspect the company may become or already be insolvent, he or she starts developing one or more courses of action that are reasonably likely to lead to a better outcome for the company. And the debt is incurred directly or indirectly in connection with that course of action and during a specified time period. So a safe harbor duty, safe harbor defense is available if directors can show that they have done everything possible, perhaps broadly speaking, but they haven't, or at least in their perception, they did whatever they could to avoid the company becoming insolvent during the time that they suspected that the company was operating or becoming insolvent. Other statutory duties in relation to financial record keeping and reporting, normally based on law, I think it's the record keeping is the obligation for 7 years. You need to record them, and obviously, as Sarah mentioned, there are a lot of duties on how you collect the information, how you, if it is personal information, how you protect them, how you record them, how you safeguard them. They're all are also part of directors' duties. Directors have an obligation to take reasonable steps to ensure that their company complies with its obligations under the Corporations Act in relation to keeping of financial records and financial reporting. A lot of companies, depending on what kind of operations you have, you may have reporting duties to different regulators, and it is part of the director's duties that to prepare those reports to those regulators, whether it's ASIC, APRA, or whatever organization that you're entitled or you're supposed to report to. They must apply their own minds rather than rely solely on advice when reviewing financial statements, and they must satisfy themselves that this information is consistent with their knowledge of the company's affairs. So they can't just rely on accountants or other professionals. They have to use their mind to determine that. Provision of direct information, as I mentioned, director have an obligation to provide to their organization or certain information relating to themselves. So this is the duty the director owes towards the company that they have to disclose, and mainly it is when they are mostly conflicted, or they have interest that is in conflict of the business's interest. In certain circumstances, directors of a proprietary companies will have responsibilities to lodge information with ASIC. So you need to know your duties as a director, whether you're required to disclose those information or not. As I mentioned, there are other laws that could be and federal or state level, like taxation laws, work health and safety, privacy law, environmental law, apart from Corporations Act, that will hold you accountable, and you have certain duties depending on the industry that you are operating in. There could be mining laws, the financial services laws. If you hold an AFSL, you provide financial services advice, for instance, then they are like ASIC rules and regulations or guidelines that you comply by. And those are like apart from Corporations Act, for instance, if you're in the aviation industry, then you will have a specific, or in mining industry, you may have specific duties under those acts as well. So if a company has operations in a foreign country, directors should also ensure their duties and responsibilities comply and fulfill any local legislations and requirements. So there are obviously consequences for breaching directors' duties, and there's one rule in law that's no matter what area of law, ignorance is not an excuse. So a director cannot be off the hook because they say, well, I had no knowledge of my duties, or like I simply didn't know I did this, so that constituted breach of my director's duties. So you have to be aware of the same as if you have to be aware of a traffic rule or any other aspect of the fact that you cannot, for instance, rob somebody or kill somebody. It's the same as like you have to know your duties as a director, and breach of that has consequences. It has criminal sanctions, disqualification, civil sanctions, or commercial consequences. A contravention of certain duties under the Corporations Act or other laws constitutes a criminal offense. For instance, under the Corps Act, a contravention of the duty of good faith or improper use of information or position, if it involves dishonesty or recklessness, is punishable by substantial fines and potential imprisonment for up to 15 years. So that's based on Section 184. So for any breach of director's duties, if it is proved, that the company employees, company shareholders, the creditors can take a company director to the court, and they can be trial, and if they are found to be guilty or in breach of their director's duties, they are facing criminal sanctions or penalties or punishment as well. Up to 15 years of imprisonment, which is huge. Civil sanctions, contravention of the duties under the Corporations Act, can make a director liable to a substantial fine. Shareholders or other, for example, creditors, may also take action against directors who have failed to comply with their duties. So civil penalty is mostly in the form of fine or disqualifications. Sections 182 and 183 of Corps Act covers civil penalty provisions, breach of civil penalty provisions for disqualification, or 5,000 penalty units, which is around 1 million. However that is, that's a fine. And if the court can determine the benefit derived and determine avoided because of the contravention, that amount is multiplied by 3. Or they can order a compensation order. Criminal penalty for breach of Section 184 is a very significant fine amount of $420,000 and or 5 years imprisonment. And then it just goes on, so different sections. So the whole idea of breaching director's duties is the message I'm trying to deliver is really serious, and it will have consequences either to the director personally or to the business, or obviously the simpler form will be disqualification. Disqualification, it means there will be a period of time that director cannot become a director of any other company. So both ASIC and the courts have the power to disqualify directors for long periods of time for failure to comply with their duties under the Corps Act, or directors are automatically disqualified on conviction of certain serious offenses or an undischarged bankruptcy. Undischarged bankruptcy is you can't be a director when you're a bankrupt. So or you haven't disclosed it. If you have a history of bankruptcy, you have to disclose it. So for directors of charities registered with Australian Charities and Not-for-Profit Commission, so the charities are managed not by ASIC or Corps Act, but it is managed by ACNC, which is Australian Charities and Non-for-Profit Commission. The ACNC commissioner has the regulatory power that is the regulatory body, an entity for charitable organizations, and they have the power to suspend or remove a director upon failure to comply with the Australian Charities and Non-for-Profit Commission Act 2012. The ACNC commissioner may also prevent a director from governing any other ACNC registered charities. Right, so charities are completely separate from Corps Act. They have different legislation and regulatory body. Director appointments, the Corps Act, consequence of disqualification. Public companies to have at least 3 directors, at least 2 of whom must ordinarily reside in Australia. So for appointments of directors in the Corps Act, there are certain requirements based on whether you're a proprietary company or a public company. In proprietary companies, there must be at least 1 director who must ordinarily reside in Australia. For proprietary companies with a sole director who is also sole shareholder, a second director can be appointed by the original director, recording the appointment and signing the records. Right. And obviously, there are commercial consequences for breach of directors' duties. The most serious consequences of breaching directors' duties are often not legal ones, but a commercial one. A corporation's most vulnerable asset is its reputation. The company will likely be subjected to much greater scrutiny, both by investors and regulators, where directors breach their duties. At worst, a market and stakeholder reaction may mean that the company will cease to exist. So if a director breaches its obligation, the entire business can be impacted. That's how serious it is. These commercial consequences likely occur before any court judgment is handed down. Media reporting on the misconduct of financial institutions disclosed during the Banking Royal Commission caused drastic falls in share prices and loss of public trust. Significant public scrutiny and pressure on board performance also saw the resignation of board chairs and directors of a number of organizations. Organizations that are not governed by the Corporations Act, as I was mentioning, are charities, incorporated associations, such as cooperatives governed by state legislation called the Associations Incorporation Act. Most states have their own legislation. Organizations operating under a royal charter, charities are governed by ACNC. Organizations incorporated by their own act. These can be state or territory acts. For instance, NIFIC was an organization that was a federal government organization. It had been established by its own act. So that act regulated the entity. National Housing Finance and Investment Corporation, if you all have heard of that, or Anglican Church of Australia, they have their own act, or they're governed by Constitution Act. New South Wales, University of New England, these are the type of organizations that are incorporated by their own act. Not by Corps Act. Government bodies regulated by their own legislation, for example, the Commonwealth Authorities and Companies Act, 1997, and State-Owned Corporations Act. All right, thank you so much, everyone. I do have slides for contract law, but I think I don't have time for that. So I will hand it over to George, yeah, we will proceed with IP law. Thank you so much, everyone.
Yeah. Okay. Thank you very much for Sarah and also for Cherie and for your excellent presentation. And just now, I see the Sarah provided very comprehensive and presentation in relation to the business structure and just like which type of business structure we can use when we set up enterprise. And Sarah and Shireen and also give Aslan summary about all the direct duties which directly relate to our personal interests and also personal life sometimes. So next, what I'm going to do is try to provide you some insight in relation to how to operate an enterprise and in the current digital environment, particularly provide some insight in relation to potential legal issue and we may have to come across and in the current digital environment, which is related to intellectual property. When we're dealing with this, basically, and I will cover 3 issues. One is what is intellectual property? Second, how to obtain intellectual property? And lastly, is mainly dealing with how to commercialize intellectual property. But before we move to all these questions, I think we have to answer one question, just why? Why we need to look at intellectual property and intangible assets? The reason is if we back to the 20, 30 years ago, if you look at all the law school, not too many law professors look at the intellectual property issue. The reason is because intangible asset intellectual property hasn't played a very important role in the international trade. So when we talk about international trade, it's mainly dealing with tangible asset. But nowadays, it's quite different because let's look at the data from World Intellectual Property Organization. More than 70% of the world wealth and resources is now all intangible. So that's why today we look at intellectual property, why we need to look at intangible asset nowadays. And when we're dealing with the definition of the intellectual property and different treaty and provide a different definition. But generally speaking, and at United Nations level, and we have World Intellectual Property Organization, which is specialized agency in United Nations, administrate all 26 international treaties dealing with intellectual property protection. But nowadays, we have to say the complexity of intellectual property is much more complex than the previous years. Traditionally, we have patent, trademark, copyright, but nowadays we also have the big data and personal information, and also the metadata and health information, fair use, money, open source movement, many intangible asset related issue involved. In Australia, basically, another agency look after and in intellectual property, and it's mainly IP Australia. And IP Australia website also provide a very good summary about the basic concept about intellectual property and how different type of intellectual property can be registered. So what is intellectual property? Put simply, intellectual property is a kind of an umbrella concept for the vast collection of law. Why? Because when we talk about contract law and contract, we have contract law. We talk about corporate, we have corporate act. We talk about the criminal offense, we have criminal law. But when we're dealing with intellectual property, we can see how many legislation we have. Patent Act, 1990, Copyright Act, 1966, Circuit Layout Act, which is dealing with the design of circuit chip, 1989. We also have a Design Act, Trademark Act, Trade Secret, and Common Law Trade Secret, and the passing off. So we can see there's so many different legislation. They all follow into the category for the intellectual property. So that's why some commentators, they believe the IP law is more just like an umbrella term that cover all these different legislation. But the common feature about this legislation, they all dealing with intangible asset. It's not dealing with physical, tangible things. And when we talk about the intellectual property, that's a domestic law in Australia. At the international level, and we have a World Intellectual Property Organization administrating the international patent and trademark registration, and we also have a TRIPS agreement and administration with the World Trade Organization. We call it Trade-Related Aspect of Intellectual Property Agreement, 1995, provide all the member country, all WTO member, they do have obligation to protect intellectual property. And in recent years, and not only international treaty, if you look at free trade agreement between Australia and the United States, free trade agreement between the United States and Singapore, Australia and Singapore, we all have a chapter, particularly dealing with intellectual property protection, special chapter dealing with personal data protection, electronic commerce. It's all part of the free trade agreement now. But when we talk about second question is how to get intellectual property registered. Put simply, and we don't have to, when we say how can we receive those intellectual property rights, generally speaking, they can be divided into two categories. One type of intellectual property actually fall into the category, we have to get it registered. If we don't get it registered through IP Australia or relevant government agency, we cannot receive them. For example, registered trademark and patent and domain name, they all subject to the registration. But on the other hand, and we also have some certain intellectual property right, which we don't have to register, but we get them naturally. For example, business reputation passing off, and also the trademark and the common law, which is related to the passing off also. And copyright basically in the United States, and they also have a mechanism dealing with copyright registration. But in most of the other countries, copyright, basically we got copyright directly, and we don't have to through the registration. Circuit layout became a tricky question, but now for the old country join the Washington Treaty, and now the circuit layout also subject to registration. Some other aspect in relation to registration is dealing with international registration. For example, patent and trademark. Why? Because nowadays, and many companies, they operate not only in Australia, they also operate overseas. And some company, big company, we're all familiar with Microsoft and Intel, they have they're multinational company, they have a trademark registered in different jurisdictions. Same with patent. And if we patent registered in Australia, but we fail to register same patent in other jurisdiction, and also we got protection in Australia, it doesn't stop other enterprise competitor and to infringe our right in other countries. So that's related to the obtaining intellectual property. But when we're dealing with the intellectual property, and in the multiple law school, actually intellectual property is a subject for the whole semester. That's about half a year program. But for the purpose of our seminar, I think I will mainly focus on more on what is IP commercialization, because that's more related to the entrepreneur to set up the business. The thinking of the law researcher and also the entrepreneur can be quite different. Why? Because when the law researcher dealing with intellectual property and they mainly focus on how the patent trademark can be registered. As even for lawyer, focus on just like how the trademark intellectual property can be obtained, can be enforced, if have been infringed, then how we can defend those rights. But for the entrepreneur, when we're dealing with intellectual property, normally from different angle, it's mainly dealing with how can we convert an idea to a marketable product, which can eventually bring revenue for us. So that's the business thinking. So it's not necessarily mean just like we got idea, we definitely need to get apply for patent for that. We need to always think about it, just like how can we convert idea to the final product, which can bring revenue for us. And then we think about just like whether we need get relevant idea or technology registered as intellectual property. Sometimes, and we have so many different types of intellectual property, but I have to say, not all of them are relevant to our business operation. For example, if we operate a furniture store, so in that case, maybe design law is relevant, but copyright, circuit layout, patent definitely is not relevant with our business. Secondly, and if we operate, let's say, and it's mainly in Australia, so it's unlikely we will have an international market In that case, when we're dealing with trademark, the domestic trademark registration, I think, will be sufficient. It's not necessarily and to get trademark registered overseas. And so we can see it totally depends on the nature of our business before we move to the expensive registration procedures. When we're dealing with IP commercialization, and one question is how the IP intellectual property and can bring revenue for us. Generally speaking, a little bit of background, and when we're dealing with intellectual property and the trademark and patent and the copyright, they are the major legislation we have to deal with. Trademark, because we all have business name, and trademark can be very valuable, and once we set up business reputation. So get trademark registered, and that can be a very common thing for most of the enterprise. For relation to the patent, that's mainly dealing with the company. For example, if you operate intellectual IT company, and in that case, it's a highly technological intensive industry. So in that case, you don't want to other competitors steal your idea. And how to protect your idea? One good way is through the patent application. So the patent application can be relevant to your business operation also. But the main difference between the patent and copyright is the patent is mainly dealing with protection of idea, the idea you have. And the copyright is different. It's mainly dealing with expression of idea. For example, if we talk about a movie, we have the novel, and then the novel itself can attract copyright protection. But if we convert it into movie, even computer game, they may all attract different copyright protection. But for patent, it's mainly dealing with idea, protection of idea. And once a patent has been registered, so what does that mean? That means the patent owner will receive 20-year exclusive rights to commercialize their technology. That means if any of us, we want to use a similar technology and those patents, which have been registered successfully and through IP Australia, and we have to pay licensing fee, and we have to get permission, get a license from those patent owners. In return, and those patent owners, they have to disclose all the information and to the public, to the society. That's the deal between the regulator and also the patent owner. They have to disclose all the information. So all other competitors, we can build upon their invention, create our own new invention. We don't have to repeat the effort they made. But we do have to pay a licensing fee. We get permission from the patent owner. When we look at those different types of intellectual property, we can see, as mentioned, in relation to the protect idea, and it's mainly the jurisdiction for the patent law. But when we talk about the expression of idea, for example, submit patent specification, patent specification itself is subject to protection of copyright law rather than patent law itself. Here, and when we talk about IP commercialization, I want to mainly focus on three aspects. Try to give you some help you to understand what's the current issue in this area. One is dealing with how the intellectual property can bring the revenue for us. Second, I will focus on the law compliance in the current digital environment, particularly focus on some issue in relation to the recent development of copyright law and consumer law. Lastly, and I will talk about some recent cases and the ACL and competition law dealing with enterprise and business operate in the current online environment. Let's start with the first one. And why it's necessary for so many enterprises to pay attention to the intellectual property. The reason is because the intellectual property can bring the revenue and profits and for the enterprise. How? For example, the use of intellectual property in the provision of a service for reward to a third party, such as contract research and the development work. The use of intellectual property in collaborative research project the license of intellectual property to the third party. And when I talk about all these concepts, they look like a little abstract. So let me give you some example. Actually, it's an open question for everyone. If you have the video open, please feel free to answer the question. When we talk about Apple, we all know Apple is the largest IT company in the world, right? But here I want to ask you a question. One country, small country, not United States, not India, not China, a small country, only have 5 million population, but they have 33% global revenue of Apple. Which country? Any idea? And let me tell you the answer straight away. And Ireland, 5 million population only, but have 33% global revenue of Apple. Question is why? Why Ireland have a 33% global revenue of Apple? It's all related to intellectual property. Because in 1980, Steve Jobs, they have agreement with Ireland. Basically, they set up the company, and Apple set up branch in Ireland, and also get many intellectual property registered in Ireland. If get a patent and registered in Ireland, what does that mean? So that means if other company, if they want to use the patent created by the Apple, so basically they have to pay license fee to the company located in Ireland. But then the question is, why they simply get the patent registered and in United States or Australia? Why choose Ireland? So that's actually the issue related to one issue actually just now mentioned by Sarah and also Sherry, is dealing with other law, dealing with taxation law. So what is tax? What's the tax rate and the corporate tax and the Apple have to pay in Ireland? Oh, let me start with some simple question. What is tax and Apple have to pay the corporate tax in Australia right now? Yeah, question for everyone. So what's the corporate tax in Australia? Yeah, could you please unmute yourself? Yeah. Yeah, Michelle, I'm pretty sure you're an expert on that. Yeah.
25%.
Yeah, 25%. And but how about in Ireland? The negotiation between Apple and basically between Apple and the Irish government basically is less than 2%. And also based on the arrangement between the Apple and the Irish government, they even can reject to pay that 2%. The reason is because Irish taxation law make clear, just like if they get the major business activity happen, it's not Ireland in other jurisdiction, for example, in the United States and other country. So if the major business is not in Ireland, they even can avoid to pay that 2%. So in that case, we can see that's how the intellectual property can bring huge revenue and for the enterprise, and also just how the different law, intellectual property law, taxation law, they may work together, generate huge revenue and for the enterprise, and particularly in the current digital environment. But another thing is we have to deal with in order to join the benefit of those technology and the revenue, and we need to know and how those companies get the sufficient ground to create those technology and the patent, right? This is a different way in relation to the technology development. It can be the research development, and also investment can be part of that, and a different state of technology development, including the research development at the very beginning. It normally should be the university or the government grant and participate this part. And sometimes we got a seed capital or start-up capital. For example, in the Pitch Night, and we will have in May, when we're looking for the investment, it's mainly just like investment, just like seed capital. We present our business idea, and some investor, the interest about our idea, they want to make some small investment and have a test, see whether our idea is really marketable. So that will fall into that category. And lastly, and it can be expansion capital. For example, we already set up a company. As a matter of fact, I know, and some entrepreneur in our group, they already have their own business. But now it's time for them to expand their business. So in that case, if they present a very good case to demonstrate the value of their intellectual property, and then it's very possible for them to get investor to get the technology developed further to expand the business and the operation. Some example I can give you is this type of grant can be the national grant. And for example, ARC, that made the Australian Research Council grant. It's mainly dealing with some fundamental research. And those type of research actually is unlikely and will be invested by the most of the industry independently. The reason is it's hard to see the profit and in a very short time period. But ARC, they do have some linkage program, which basically is an enterprise industry will invest at least 30% provide 30% grant, but the national government will provide 70% to the university. And so eventually, and university and industry will work together to create the new technology. And some other grant, and even some grant available actually for we call it community grant, even for non-profit organization. For example, and one of the current the grant application we have been currently working on is the Import Foundation grant. That grant basically they provide the investment and for non-profit organization, and so long as those non-profit organizations contribute to the community well-being. So the current project we're working on is basically OA and UTS Artificial Intelligence Center and IPF try to work together. So for example, set up AI import the mentoring program. So the program like this may fit into this category. Those type of grant actually it's not pure business grant. It can be the certain grant for even for non-profit purpose. So that's some simple example about how the IP can bring the money and how we can fund the grant and relate to our business operation, whatever for profit or non-profit. The second issue I want to talk about a little bit about the IP commercialization, about the intellectual property law. And particularly when we're dealing with IP law, because I noticed a few speakers and in our group, actually they all try to set up a website, a digital platform to promote their business. So when we set up the digital platform and website to promote our business, in that case, we do need to pay attention to some potential liability we may have. For example, ISP safe harbor legislation, that's something and new after we signed up the free trade agreement with the United States, because the whole system was from the States. Generally speaking, and let me briefly introduce how this scheme works. Assume we all member of Facebook, right? So Facebook actually is fit into definition ISP, internet content provider, service provider. If we set up platform, just have similar function, for example, can hold information for different enterprise to operate on our website, we also fit into the role of ISP. Traditionally, copyright law is only dealing with relationship between copyright owner and subscriber, copyright user. For example, I a movie producer, so I'm the copyright owner, and all of us are the customer. We watch movie, right? We are user. But how about if one of us and in the cinema we infringe copyright, we videotape the movie and put on the Facebook. So in that case, for the person uploads the unauthorized material and definitely will breach the copyright law. But then the question is, they using the electronic facility and also the infrastructure provided by Facebook. So would Facebook be responsible for that? So so under the copyright law, and if they facilitate such kind of process, they have we call it vicarious liability, secondary liability, and for the copyright infringement. But certainly it's not something the ISP they want. So now the Digital Copyright Act makes them provide immunity for them. Say if they receive a notice from copyright owner, for example, movie producer told Facebook, your user infringe our copyright. And if they receive notice, they take it down immediately. In that case, the ISP will enjoy full immunity. So if we operate just like we provide a digital platform and we have lots of subscribers, so we need to be aware, and it's possible. And we haven't breached the law, but if our subscriber upload some information which are unauthorized, and we may be liable for that. So in that case, we do need to monitor and all the activity of subscriber and on the website. Particularly, we need to have a contact about internet content provider and the contact which is available for copyright owner. So if copyright infringement happen, and which all copyright owner should be able to approach us. So long as we take it down immediately, then we don't need to take any responsibility anymore. Some other issue we may also need to pay attention is the current law and operate and also make the operation of some company and overseas, and even they operate overseas, and they may all have liability under the legal liability in Australia. Typical example, and I want to give you two examples here. And one is related to the issue Sarah mentioned, and in relation to the application for Australian consumer law, misleading deceiving conduct. Another one is dealing with the issue and Cherie mentioned about the operation of the company who have headquarter office overseas. So let's have a look at the first one. And in this case, that's a case in 2017, ACCC and the brand case against Merton. The reason is basically the Merton, basically when we see, for example, when we want to book the hotel, normally we will look at the TripAdvisor, right? The review record, Google review record those companies have, right? But the ACCC in that case, they found they try to manipulate such kind of process. They try to delete and or not send and the email or the link and to the subscriber, their client, which may have the potential and to post negative feedback to them. So in that case, the ACCC believe that can be a practice and potentially breach section 18, misleading deceiving conduct. So that means when we operate online, particularly in the digital environment, and when we deal with the Google review of this, we need to make sure we action honestly. We cannot just like, for example, hire people to post fake review and even post review feedback on those websites. Otherwise, that can be a breach of section 18 and ACL. Some other example I want to give you is sometimes like Wolf case. So that's a case dealing with cloud computing technology. And the Wolf is a company in the United States, and they don't have any premises in Australia. They don't have any bank account in Australia either. And also, and when they sign up the user and in Australia sign up by the Wolf's computer game service, the website make it very clear the law in the United States will apply. Australian consumer law should not apply. But in this case, and ACCC basically brings litigation against this company in the US. On the ground what? They breach Australian consumer law. So the US company, the argument is they don't have any premises, any data center in Australia. And they also don't have any employee, even bank account in Australia. But ACCC still believe Australian consumer law will apply. The reason is, let me give you a very simple example, and you will see and why High Court eventually made decision in favor of ACCC. Because they have nearly 2 million subscribers in Australia. So think about the population in Australia. They have more than 1.2 million subscribers in Australia. The whole population in Australia is 25 million. So we can see that's huge. And also they haven't really provided the refund policy and on their website. So that means if the Australian subscriber not satisfied with their service, they cannot get any refund from this US company. So that's why eventually High Court made decision in favor of ACCC, impose $3 million penalty against the US company involved. So that's from this case, we need to be aware. When we operate online, and we need to be careful, we always need to pay attention to the Australian consumer law. So even we not using the data center and the premises and in Australia, and the Australian consumer law can still be relevant. And lastly, it also can be something and relate to our practice and is dealing with the email. And when we're dealing with the e-marketing, and last week, and we have the mentor and instructor tell us a lot of strategy how to send email to expand the market. But when we send those marketing email to the potential customer, we also need to pay attention. We need to follow the Australian Spam Act. Particularly, it's important for when we send an email, we need to have something. That's the email I received. You can see, provide a link enable to our potential customer to unsubscribe the email we send to them. So that's a very small, tiny thing, but it can be related to our marketing and also daily operation. So basically, that's some 3 examples I give you. And thank you very much for your attention. And I'm happy to take any question you may have. Thank you. Yeah.
Thanks very much, George, Shahari, and Sarah.
I think my question is, because, yeah, you are right, like the whole copywriting and patent is not a physical selling point. And I know there's no authentic idea in this world anymore by 2022. So how do you kind of make sure that what you are copywriting doesn't infringe upon something that you might have never heard before, but someone might come out of nowhere and say, hey, that's my idea? How do you make sure that doesn't happen?
Oh, I think I will take that question, right? And
yes.
For the copyright, actually, that's something we need to pay attention. The patent right and patent law, copyright law, they're different. Why? Let me say it in this way. For example, if I'm the programmer, I design something, apply for the patent. You're also a programmer. You design exactly the same thing, have similar function. You also try to apply the patent. But unfortunately, and I apply today, you apply tomorrow. So in that case, if I got registered and in advance, and so basically I will got a patent right, you will not get it. So it both just like who fell first, that we will get it. And even the technology we invented as basically created independently. But the copyright is different. Copyright can be something, for example, I wrote a song and you wrote a song exactly. I wrote a song 5 years ago. You wrote a song yesterday. But we all done it independently. So in that case, both of us can claim copyright on that.
Okay.
Yeah. Okay. So, but the copyright can be a problem, for example, and if we have a movie and you're a movie producer or you're a short video producer, and you have your short video produced and you spend lots of time, investment, money, and to create a short movie and put it on your website. But other people, they just repost your video without notifying you or pay you. So in that case, assuming if they repost your video on the Facebook, in that case, and those people who repost your video, definitely they breach your copyright. You can sue them directly. But sometimes, and the people, instead of sue those infringers, they will sue the Facebook instead. Why? Because Facebook is a private platform. So if they sue Facebook, they sue single company. But if they sue, for example, with the user, let's say 500 users, they all use Facebook, upload, share your video. In that case, they have to sue 500 the infringer, right? So that's why they have strong incentive for them to sue Facebook rather than sue the direct infringer. But if we operate like a provide digital platform service, a little bit like Facebook, in that case, it's very possible, and those corporate owner will bring the issue to us. And in that case, and we do need to think about how to deal with that, and certainly need to sometimes get some expert opinion on that. Let me give you an example. Actually, sometimes it's not that sophisticated. For example, even Australia and United States have all have the law dealing with ISP safe harbor, dealing with notification scheme. If you receive notice, you have to take it down. But in the United States, what they found is among 3,000 notice the copyright owner received, only 1 or 2 of them are valid. Why? Because the development new technology also bring lots of things about law enforcement. For example, when the ISP legislation was created, so basically, and everyone using the not P2P model, it's more just like using, we have most of the companies, they have the big web server. We can say that's more just like big computer. And everyone uploads unauthorized material to the web server. So in that case, if we are ISP, we receive notice, we can take it down, right? But with development of peer-to-peer technology, those unauthorized material is not on the Facebook web server anymore. It's in our own computer. They simply provide a link to facilitate the download of the unauthorized material. For example, you found my link, and I have a copy in my PC, and other Michelle and other colleagues also have that copy. So in that case, you can download that copy from Michelle and my PC, and even 100 other people's PC automatically. So the speed will be extremely fast. But as Facebook, they don't have capability to take it down. The reason is because it's not on their server.
Yeah.
So
I'm just thinking more of like, so for me, I'm not selling anything. I'm not developing a technology.
Yeah.
It's more intellectual property in terms of like creating workshops and content. And so I know my idea is not unique. And that's where the questions come from. You know what I mean? Like, where can you, I don't know, just safely copyright your ideas, although they're not necessarily 100% unique?
In that case, that should be fine, because but when we operate the workshop like that, one thing we need to pay attention is we provide those workshops, and for sometimes even for not for profit, for public purpose, but we need to be aware, see whether we may infringe other people's copyright or not. For example, back to the 10 years ago, one of the projects I have been working in the Harvard Berkman Center. Basically, at that moment, MIT, they provide more than 200 free online programs for the students around the world. It's all for free. But it only operates less than 1 year and have been stopped. Why? Because they provide free education resources, right? They not make profit from that. The problem is when they operate the program like that, they have to upload some teaching material. For example, book chapter of certain author. So in that case, they provide free program for public benefit, but they have, when they providing such a service, actually they may infringe other people's copyright. So that's something, and that's why eventually they stop that project. So in that case, actually, if you offer a program online through the digital platform, in that case, you do need to be a little bit careful, see whether you got lessons from those copyright owner. And as a matter of fact, many online copyright resources, and actually they now is under Creative Commons and license. So that means for education purpose, and they may, some copyright owners, they already give you the license, free license, so long as it's for education purpose. So in that case, what I'm saying is not saying that your basic model and cannot operate, but just like the information you post online, you need to make sure you already got the authorization from those copyright owner. That's quite important. Yeah.
Okay. Thank you so much.
No problem. Yeah.
I have a small question. It's Emil here. So thanks, George, Sarah, and Shahari. Was very informative, especially the legal stuff. It's always, it's not an easy. So basically, my name is Emil. I'm one of the co-founder at Vive Life. So we actually selling membership as wellness live membership. So we have instructors, global instructors, where they deliver wellness classes, yoga, meditation, and the whole mix. The first question we get asked if there are insurance that covering, the instructors, and we tell them it's always covered in the T's and C's. All employees, the customers at home, they're covering themselves basically for any injuries or anything that might happen, because it's your home. You're meant to be looking after yourself basically. And that's, we compare that with our competitors, and they have exactly the same kind of T's and C's. So the other question is, I'm just wondering if that's good enough as insurance side of things, as in the T's and C's, or we should buy an insurance, and what type of insurance for such life classes?
Assume that's quite for Sarah, right?
Hi, Emil. I mean, that's complicated in the sense that I don't even know what kind of product would be available in relation to kind of when you're encouraging people to do things at home. Whether I don't know if public liability insurance would even cover that. It's usually third parties that public liability covers. So like I feel like I have to have an insurance broker here to talk about what products are available, because there would be various products. And I don't, because you're just assuming everyone just has home and contents insurance, and within home and contents they might have some sort of public liability element. But the public say it again, Emil?
It's global. So some places are third world countries, or some places they might not have insurance at all.
Oh, okay. Yeah, I mean, I can't talk about other jurisdictions, but I can, in terms of in Australian jurisdiction, because you've said, I mean, maybe that's what you need to make sure you're making clear in your terms and conditions, that the responsibility lies with them to ensure that they're appropriately insured.
Yeah.
Rather than, you being personally, your company or yourself being liable for.
Yeah.
So maybe that's when they sign up, that's what you need to make sure you're considering, that they have the appropriate insurances. The things that you can't contract out of are concepts like negligence. So you can't, in a contract, you can't actually contract out of that responsibility. But I mean, it is a complicated question because it's about liability, and I couldn't answer it confidently without spending some time thinking about, what that relationship is between you and your users, and what type of insurances are available, what the products are. I don't know. Shari, do you have any other perspectives on that?
Oh, I totally agree with you, Sarah. It just depends on assessment of the nature of the business and how you operate globally, and I totally agree. You need to clarify that in your terms and conditions, and also your local insurance sort of covers. You need to disclose to them that you have global operation, and whether that means if they have any covers that can sort of extend to those operations overseas as well, which is highly unlikely. But again, having your instructors, which I'm assuming they'll sign up online to your business or to your platform, and then they provide online training. Is that what it is? So if you can perhaps avoid some level of liability by disclosing that on your terms and conditions, that you need to have your own insurances based on your local laws when you sign up to become an instructor to my platform. So that's what one avenue you can proceed with.
Kumar, do you have any insurance brokers that are part of your collective? Because insurance brokers are really good because they know their products and they know,
exactly
what's the appropriate product for each circumstance. So I like to engage with brokers and have a chat to them about what's available. And if you don't have any, like I know some insurance business brokers, but I don't know, Kumar might already know some as well.
there would be some brokers in contact, but in terms of having some of the brokers in our team, we don't have any, unfortunately.
Okay.
I know a good insurance broker if you want to have a chat with, to give you some basic understanding of how some insurance covers may work, or give you some options given the nature of your business. Yeah, but you definitely have to protect yourself no matter what. Yeah.
I also have a quick comment here. I think it can be related to your and other colleagues' business operation also, because when when you operate a business like that, certainly seems like you have a client from different jurisdiction, different country. In that case, and actually that's also issue, and to my colleague just mentioned, you also need to be aware, just like a potential liability dealing with personal data protection. For example, if the client is in Australia, but you have to share your client's information with some colleague and your partner in other country. In that case, and the Australian privacy law make it very clear, you must need to make sure, and in that country, the level of privacy protection will be same with Australia. So it's not always that difficult. For example, and when the United States try to sign up TPP and the Trans-Pacific Partnership Agreement with Australia, actually both countries, they already have a memorandum. So basically, Australian government promise and will provide the US citizen data as the privacy protection received in United States, and US and also promise they will protect Australian citizens' data as the privacy protection they can receive in Australia. So in that case, when you choose a partner, and for example, if you partner in the United States, so generally speaking, you don't need to worry about the sharing. The risk of sharing personal information will be much less than the risk to share, for example, information which don't have an agreement with Australia. Yeah.
Yeah. People have to go now, so I think it's time to wrap up, really.
Yeah.
I have to put my kids to sleep.
Me too. All right. Thank you so much, everyone. Thank you, Kamal, for the opportunity. And congratulations, everyone, for embarking into a new world of business, becoming directors and opening businesses. So, wish you all the best.
Thanks so much. It was really, really insightful.
Thank you very much.
See you all at the graduation. Yeah.
Before you all go.
Thank you.
Before you all go, so last week, so next Wednesday, we'll be doing the practice for your pitch. So I hope you're practicing there. And we'll meet for the practice. And before that, if you could provide the text, which I mentioned, so I gave a sample of that before, and then the Snap video. So we need that for promotion purposes, ASAP, really. And we only have 1 month, so yeah, please provide that. Thank you very much. See you on next Wednesday. Have a good night.
Thank you.
Bye.
Bye, everyone.
Bye.